simple and precise is what people are looking for in the corporate. So writing 700-page documents don't always serve the actual purpose. Money will go so far, but there is a fair amount of sacrifice, and it would feel more and more like a sacrifice if you did not feel you were serving that.
Joining us today is Tito Isaac, founder of Tito Isaac & Company. With over 25 years of experience, Tito has led his firm from a one-man practice to now a full-service law firm, handling complex multi-jurisdictional matters for clients ranging from individuals to multinational corporates. His unique blend of litigation and corporate law expertise offers invaluable insights into navigating legal challenges, whether you're an individual defending a small claim or a multinational company planning to list on the stock exchange.
As long as your definition of good and great is not by the cars they drive, I would say that you need to be able to trust your lawyer.
Tito, thank you very much for joining us.
John, thank you so much for the invitation. I think you have been too kind in your introduction of me.
You've been in practice for so many years. How did it all begin?
Well, it began even before I thought I had a calling to do the law, because my family were by and large lawyers. So my father was a lawyer, although he started off as a police officer for many years. My eldest uncle as well was trained in the law, but went on to work in the university as an officer there. And my youngest uncle, Tito Isaac, who lives today, is also a trained lawyer and ran his own firm. So I had a lot of interaction with lawyers in my youth, and it just seemed so natural. The conversations held at the dinner table or, in the group of friends was always engaging, was always thought-provoking.
With all these legal minds around you, was it one of pressure, a voice saying that I have to be the same, otherwise I would disappoint? Was it a bit of that or none of that? Or was it more of an inspiration to say, this is who I want to also be in time?
I believe it was more inspirational than ever a kind of commitment to having to follow in the footsteps of your father.
But from graduating to your first job to eventually going into private practice, what made you choose this path? Meaning, either you could have gone into government service, which I understand there was a stint, but eventually settling in private practice and very quickly, maybe almost immediately, running your own shop as opposed to working for others. What was that like?
Comedy of errors, actually. But looking back, I think if we start with the degree, I think my father's input as to where I attended ultimately mattered, because back then Leeds University had a great law school. Some of the major textbook writers were there, some of the leading editors, Winfield and Jolowitz on thought. Professor Rogers was one of my lecturers. If you talked about constitutional law, Walker and Walker, Professor Clive Walker was a lecturer of mine. And there were so many other luminaries serving in that faculty. And learning the black letter law from people like that, was amazing. We used to have a nickname for Professor Rogers. We used to call him God in a suit, because the brighter students would get together and try to formulate questions to trip him up. But you'll never get there, because he was God in a suit and he had the answers. And I remember very early in my practice, I actually called on him to give an opinion on some matters.
Is that right?
Yeah. It was still very, very interesting. Of course, today we have grown some amazing legal minds. And I believe my background is not dissimilar to yours, John. You served as well in government service. And I think we both found a different way to serve. Coming out into private practice was a little scary, I must admit. I came out primarily to answer the call when my father was unwell. I came out to assist for a while. And I think once other family members were stable and able to run that practice, I moved off and started up the firm as you came to become a member at some stage. So it's been quite a journey, and I would say no regrets. I don't know how I could do it any other way. Yes, there will be moments that I wish I could replay and do them better.
Sure.
But outright regret, no, I can't say I have that. I think from every failure, I've moved on to a different strength.
What has kept you going all these 15, 20, 25, and now pushing into 30 years?
Two things I want to say. The first thing is the point that you called. We're in this for people by and large, right? Because we know we've established or created or developed a skill with accompanying knowledge that enables us to serve. But don't forget that even behind the largest of corporations, you will be dealing with some group legal officers, some less senior legal officers. you will deal with management and executives that all have a reason to reach out to you. And their reasons can be compelling.
Mm.
So no matter where you are and what you do, you are finding a way to serve. And that keeps you going. That's your motivation. No two cases will be identical because no two persons are identical. No? And you're going to encounter different motivations, different problems, different issues, different challenges. A case could be simply point A to point B, but you're not allowed to walk that path because it offends against some other right, rule, or decency.
That's right.
Right? So we have to find a way to deal with it.
Okay, so if we pause there and start talking about today, the type of work that you do, what does that encompass? And for the less initiated, whether it's corporate law or whether it's litigation, what buckets would these either easily or not easily fall into currently? And how do you get here? How did you come to being able to master so many areas of law?
I don't think any lawyer is going to claim that he has mastered his area. He'll probably know what he doesn't know, and today we can figure out where to find that information. So what I would say is, what I do today primarily would be for example, litigation at its hearing stage. So you're talking about trials and arbitration. I'll be involved with some of the hearings, some of the preparation of documentation, especially if it relates to evidence. From the boardroom perspective, I've had the opportunity to sit on several listed company boards. I served as a non-executive chairman for a time and lead independent directors in a variety of areas and businesses. And that has to some extent kept our corporate law skills alive. From that perspective, I've also enjoyed that area. And from that area, once again, we give advice, we look at potential issues, we try and couple them with the desire of that corporate or that client. And I think that really helps a lot in terms of bringing that experience, because of the kind of things we've seen, whether it's like yourself, an industrial accident. You've seen issues arise in employment, right? You would have seen decisions made in respect of what to charge, when to charge, how much to charge, and how that may have repercussions on the market. Today, we live in a completely different world with tariffs, right? So there is a lot of information that we draw from our experience, and there's a lot of external information as long as we are open enough to take that.
But before you arrived at being able to do so many things, even without having to master it and continually still learning and perfecting your skills, how does one begin that journey to decide? For many people who are observing on the outside looking in, the perception is when you graduate from law school, you then pick an area that you want to specialize in, and you follow through with that. And then along the way, if you want to choose something else, you choose. And so, for many observers, what I sense is the misconception that you pick the subject, the area of specialization, and you follow. What you have is something that is different. You have a very broad base and a very broad spectrum of skills and a very, very broad area that you cover, from things that involve going to court, we call that litigation, to things that are non-litigation related, maybe more advisory, maybe dispute avoidance. Or how did you rather begin on that journey, and how did you move along the way?
Okay. Before I speak about myself, maybe I will say this. We are now coming up with a new system where a young lawyer would serve no longer 6 months, but almost a year in a law firm.
As training.
Yes, training. And part of that process will be to enable that lawyer to try perhaps different areas and get a feel. And what we find with younger wannabe graduates and graduates is that they would have done various stints in firms like yours or mine as interns.
That's right.
And they'll get a taste of different areas by then.
Yes.
To me, that really does help them have a feel like I either want to be here or here. And I'm an advocate for not specializing too early. I think one of the greatest blessings I had was I couldn't afford to specialize. I had to learn whatever came to my plate. And I was never ashamed to ask. And what I found is the fraternity was always very open to a young person desirous to learn from someone he considered more experienced or his superior. and that handing over and sharing of knowledge, or even the directions of where to look, I like to think that hasn't changed. Yeah.
But it also has a lot to do with what you mentioned, which is the willingness to take on something that you may not be a master of or familiar with, but are keen and able to devote the time and energy to learn and pick up. And I remember this is something that you would say very often, which is the training of an advocate or a barrister is to accept and take on the brief that you are given. And it could be something that you do every day and you're very comfortable with, or it could be something very new. And your training should equip you with the ability to then approach that problem afresh and systematically using, the same formula and the theory and the sequence of, steps to problem solve, work through, identifying the solutions, and then, implementing it.
Agreed. I would say that with the role of an advocate, for example, we would look at strategy primarily, trying to understand the desired outcomes of the client, working into the area. As you know, today, you are unlikely to be blindsided by an issue or an area of law because it is now so much more open, right? The average person will come to you and say, I think I'm caught by the Poisons Act, or I think I'm facing this issue. So we already have a starting ground. I think what makes us able to serve is that willingness to keep the mind open. Are there any other areas, anything else I'm not seeing, I'm not certain of, and looking into that? So yes, I think back then when we were coming up, John, I think that openness was very important, and finding our ability to contribute to that issue. Whether it's by our willingness to advocate for the client, right? You've been willing to speak, I've been willing to speak. The willingness to strategize with the client. Even when people think this is a sure lose, right? But you always find something. How do we help that person, right? Navigate what is sometimes a very opaque area for them.
Correct.
But it's our daily meal.
Correct. Your corporate lawyer brain and your litigation lawyer brain. How different are they, and how can they complement each other in your practice? And do you often call on both brains, if you call it that?
So if you have defined it in those two ways, well, keep that definition. And what I will say to you is, by and large, you would, depending on the issue, right? So if you're serving a corporate in, for example, a litigation matter, your understanding of that corporate's business, their expectations or their exposures, which requires some element of corporate knowledge, would help them for certain in planning what is acceptable as an outcome, what is unacceptable as an outcome, and working towards those things. Having the opportunity to prepare even for that meeting is critical. So you don't come across as familiar unless you have taken an opportunity to just get up on it before you begin, right? Because there will be issues. For example, you are sometimes asked to advise upon something relating to the Securities and Futures Act, whether something is misleading as an announcement, for example.
Correct.
In a situation like that, you're bringing together both sides of it. You're bringing together your corporate knowledge scale as to what could amount, what does it really mean? What are we trying to protect the public against? And then has this set of actions breached that?
Does it constitute a criminal offense
For
or something
example.
that you need to report?
Yeah. So you would call upon that. I think many lawyers can. It's just that no one wants to brand themselves as being a jack of all trades, right? And it's today it's important. I think it's becoming more and more important to come across as having specialized. To have an in-depth knowledge of X or Y. But as I've said to you, many barristers would want to master their brief, whatever that brief may be. I still maintain that some of the skills that we bring into a courtroom or into a boardroom remain very relevant today.
Agreed. And just picking up on that, you gave the example of the corporate entity that you're advising or helping deal with a possible breach of the securities regulations. So that's one example. Are there other examples where you have felt that your ability and your familiarity with both has been an advantage? This dual expertise, has it provided a strategic edge to your ability to help?
So whether you're sitting, for example, as an independent director on a listed company, some of the issues that these entities may face will certainly cross into that realm, perhaps of the litigation, arbitration arena. And at the same time, they have obligations to their shareholders, to their listed entities and so on,
Correct.
where they have to perform and they have to basically balance these things. And we come across as that ability to balance. How do you express, how do you assess this risk? When we look at a claim, for example, as lawyers,
Yes.
take an industrial claim,
Yes.
right? If I give you a set of facts and I give you some insight as to the nature of the claim, injury sustained, you would already, in your experience, already be able to gauge what is the potential downside. Could the company be blacklisted because of
That's right.
right?
Yeah.
Or would the company face a sustained fine? Could the directors be implicated?
And also, how is the reputation affected?
Absolutely.
Or does it have to make certain announcements if it's listed? So
You know it, you see? So you're calling on both sides. You can call it litigation, but the truth is you're also looking after the corporate angle.
So better, I mean, it's a difficult question to answer with one single word or sentence, but is it better to then have the ability to call on both as opposed to being too specific or too specialized in one area only?
I think I've been fortunate enough, and I like to think that that has helped me. But in today's day and age, the average chap will tell you, I'll just bring two lawyers. Right? But they need to be able to merge that knowledge and come up with a strategy that works for
That
their
is
client.
coherent.
Right?
Yeah.
And sometimes it's about even just organizing what happens first and what will happen after. It can be as simple as that, but you just need to know how that sequence would work.
So jumping back to what you mentioned about legal training. So you're, 20, 30 lawyers, 50, 60 people strong or more, and you have people applying to you, people being trained by you, and even though it's not your responsibility, but you play a very big part in training the talent for tomorrow that will be helping people and will continue to serve. So with that in mind, what is your approach when you receive young lawyers or would-be lawyers? Do you actively try to continue your tried and tested personal approach, which is don't specialize too early, get a broad view of everything, keep an open mind, willingness to to do hard work, don't count the hours, right? Just roll up your sleeves and do more. Would it be more of that, or would you, in today's day and age, with a slightly different market and audience and mindset amongst younger lawyers, if there is one, a different mindset, would you do things differently?
Let me deal with that in stages. I think the first point of contention for me is whether or not this young lawyer wanted to do law first. If he or she is someone that wanted to be a doctor or a dentist, then this will be a very tough call because you need to feel that belonging to the profession and that willingness to serve in order to keep you motivated for the long term. Money will go so far, but there is fair amount of sacrifice, and it would feel more and more like a sacrifice if you did not feel you were serving and giving that. So starting out, looking at that young person and making sure that you have chosen this path. And you chose this path with your eyes open. Eyes open because in the early years of any practice, one must be that sponge. You can learn from everyone around you. Even a senior secretary will have something to offer you as a young lawyer. So first port of call, I think, is that willingness to learn. In terms of how we came up as lawyers, that's probably the best way we know how. Is there another way? There may be another way. It's just not a way that I'm familiar with or comfortable with, and that I would think I am giving the best to my young applicants, by taking them on a different path. I still look at it from the perspective that we used to learn even by osmosis, just by being there, watching how the interaction takes place, looking at how the boardroom, conference room is controlled.
Observing, right?
Observing,
Yeah.
right? And there's so many elements to it, right? Because without building that rapport with the client, how are we going to have him trust you with information, right? So I think there's another aspect to it, which is For me, I can only impart my knowledge and my experience by showing you what I do. When I tell you, let's be as humane as possible, you won't understand what that means, right? Till
Unless
you
you
see us.
experience,
Till
you
you see us in a
experience it
room.
at close quarters.
That's right. When you see a crying family, you say, I'm very sorry for what has happened. I need you now. Calm down and give me facts and give me information. And you can't do that on a video screen.
And you can't only learn that from a textbook or from a webinar or from a video tutorial. It has to be something that is learned on the ground in the presence of somebody doing it.
And keep interacting with human beings, right? That's
Yes.
the only way you figure out. Bandwidth is very wide in terms of what people can tolerate, take, or learn, understand.
Still relating to legal training or career, and maybe just to inspire people who either have some thought or have a very clear idea that they want to be lawyers. It's also becoming, again, I don't have numbers, but my sense is that it's becoming increasingly common and acceptable, or maybe as expected even, for people to go embark on another career first before ending up as a lawyer. We were lucky enough to have ended up in the career at the first go, but we probably receive applicants or have colleagues or staff who have taken a slightly different path. What are your views on a person having a more varied experience and CV, if you will, before coming to law?
I think law is an amazing field where any other valid experience you have in life, in business, it just adds on, just gives you another element. Law just gives you that.
Would you
next
say it's an
element,
edge, gives you an edge, or?
Absolutely.
Yeah.
Absolutely. So I would say that if, for example, that applicant to us,
Sure.
wanted to do law, but those opportunities were not open, we are not
At the time.
at that time, then obviously if that passion still burned bright and they were just saving up and waiting for the right time, I grab that resource. Because you know that dedication is there. They want to do better.
And now, as speaking as an employer yourself now, and with people that I know who have that very experience and who have proven it to be an edge, are there any? Does it validate your decision to say people who have? I think we can count amongst your very very robust team, people who have been either educators before, either people who have worked in public service, people who have also run their own businesses, small and large, worked for multinationals in the corporate environment. Does that validate your not decision to only take people with a varied CV, but to continue accepting and looking for people with that edge, with that additional layer and perspective?
I think that should always be on the cards. We cannot just cling to what we think are the best applicants for the job from the perspective of academia. I think experience matters, life experience matters. In other jurisdictions, for example, in the US, law is a postgraduate degree. You've got to have a degree in something else first before you can come to the law.
Sorry to interrupt you. So what would be the reason for that? What would be the reason for the powers that be to engineer and set up the system such that it is a postgraduate degree?
I don't pretend to read their minds, but I could understand. My take on it would have been that they want a certain level of maturity. They want exposure to other areas, and then when you see the law come in and apply to it, it just brings it makes it alive, right? So if you were looking at you were working in bioscience, for example,
correct.
and then you come to the law later, you'll understand why we have certain regulations, and how you handle matter.
And also the training that you've had to go through in a completely different area, whether it's structure, rigor, protocol, systems, that also brings another layer to how you approach things.
And the maturity, Joe. Because when we serve as lawyers, and you know this, we leave our issues behind. Our problems don't matter. Our concerns of the day do not matter. When we step into this office, we put on the jacket, right? We are the lawyer. And we are here to serve. We're here to help. We're not to worry about our problems, right? And that takes a certain level of maturity, right? Where you can leave your own issues behind and just dedicate yourself to the issues of others.
Where does good lawyer start to blend into great lawyer. Meaning, what can a person do intentionally to be better at what they do, right? This is for the lawyer, but there's also another reason I ask this for people who need lawyers, for people who engage lawyers, for people who depend on lawyers. I feel it's maybe useful for them to know what to look out for them to be able to decide or to discern.
As long your definition of good and great is not by the cars they drive, I would say that you need to be able to trust your lawyer. You need to have that comfort and confidence that he or she as a lawyer understands you, understands your issue, knows what you want in terms of an outcome, provided you yourself are being rational and reasonable. But I'm certain if you are not, your lawyers would disabuse you very quickly. Yeah. So I think trust is a key factor, and you will know whether that lawyer is going to be good for you. You're going to feel that level of confidence. Even for you, for example, many cases that you deal with, John, you know the outcome can be darkness or maybe a little bit of light at the end of a tunnel. And that's what you're trying to give them. You're trying to tell them that, yes, there is a dark tunnel to walk through for what you may have done, but we'll get you to the light.
But it's also how you package and present that piece of less positive news, right?
Of course. And
Or
it's reality, right? It's the reality check that we have to give. Also, it's important that we try to give back when we can. What you've done in many of the charity cases, pro bono cases. Yes, that's one part of it. But and I know, running a firm today, we have to reinvest in our talent.
Correct.
Right? So we also need to make our fair fees.
Agree, and couldn't agree more. Trust, getting a sense of whether this person really cares, is genuine, sincere. These are things and keywords that I say to my team when I train, or I say to prospective clients even when I say it's okay after this conversation. Speak to a number of other lawyers to get a sense. Otherwise, and I don't know whether you agree, and you don't have to agree with this, but I say that not as a marketing tactic, but I say that out of sincerity to say, I can't convince you how much I care until you maybe unfortunately speak to someone who doesn't. And then you'll be able to tell fairly quickly. And when I say it like that, it may sound like it's a marketing ploy, but it's not, because I feel it's also important for people who need help to be able to make that decision in a very well-informed way. And there's a reason why I say that, because and this is how I think both of us set ourselves up in terms of presenting ourselves to the outside world, which is we put ourselves into other people's shoes. They call that empathy now, but it's really knowing that what we take for granted in terms of jargon, terminology, procedure, rules, facts are complete gibberish and alien to people listening for the first time. So why I say that is that people who need help are impressed by this. They are impressed by the more jargon you can throw at them, the more important and intelligent you can sound or make yourself out to be. That sometimes ends up giving a certain impression. And if the listener is not enlightened or aware enough, it's easier to, it's not a trap, but it's very easy to just choose with the eyes. Bigger office, better. Longer CV, better. And in different stages of our life, we've had to encounter that, right? Because when you only have 2 years under your belt, you can't suddenly make it 22. And when they say you've only got 2 years of experience, but this person is 12 and he's done all these cases. And the impression is that they are better because of these other things, or a fancier office, or other outward aesthetics. And I don't mean to say that that is a real problem, but I sense that that is a situation that is out there.
And I think that will continue to be the way some people decide and judge things when you don't have time to decide or discern who you want representing you, who is going to be your voice. You look for the one that seems the loudest or the largest, right? Something we perfectly understand. However, for those that have the time, the energy, to discuss, they will get that feel of who is best to represent their interests. and in what capacity. It's there have been occasions where I've just been the advising solicitor on international cases where we retain other legal talent in other jurisdictions. There was a time when I had to run a case in Australia, London, Brunei, and we were just the supervising solicitors, making sure that legal teams got the message right, what they needed to do, right? So there are many ways in which I think we'll come together, we'll serve, we'll do things the right way. I don't believe that anything in the market or the industry, I think you raised the point about the jargon that's being used. I can tell you today, simple and precise is what people are looking for in the corporate law.
Agreed.
Right? And I tell people this frequently. However well you write your agreement, what's really important is that opposite hand of yours. When you shake the person on the opposite side, is there already some element of trust and confidence that makes up for a lot of the agreement? Yeah. So writing 700-page documents, don't always serve the actual purpose.
So quantity doesn't always.
It doesn't always do
that. And that
doesn't always.
Yeah, that can be applied in so many different ways, whether you're choosing a lawyer, whether you're approaching your case, or you're choosing the legal solution that has been proposed to you. Bigger doesn't always be better, and more expensive, it doesn't always have to be better, and may not always be better.
We continue to, I guess, evolve and improve. I think there was a time, John, when we could do cases alone. These days, without the supporting staff, the junior lawyers along with us, keeping pace and giving that speedy access to justice is what we're striving to deliver. Is no longer an easy task.
I'm going to ask the last series of questions, but before I do that, it's related, and I've touched upon it earlier, which is for someone who does a lot of work that relates to corporate entities, i.e. things that are not less humane or less human, but because they are a bit more corporate in nature, a bit more commercial in nature, and therefore the sense is that they don't have a human element. That is the reason why. For somebody who does a lot of that, how do you continue? And you don't always get to choose which cases you take on. They come to you, and you deal with them with good intentions, with good faith, and with your best efforts all the time. But with a practice that is not primarily but heavy on the corporate, how do you continue to keep yourself connected with the idea of service? Because I don't know, but my thinking is that it's hard to find sometimes.
The corporates themselves have a very high expectation of the service they want to receive, but we have to make sure that we are actually hearing what they really want. We're listening to what they're really saying. Sometimes it's a clear-cut matter where it's basically just achieve this objective, and it's very clear what the objective is. Then there's not much that you have to read into beyond that. But there are occasions where there are nuances. Where, for example, especially in employment, where on the one hand, you feel that this person cannot leave in this way, but on the other hand, you don't want to punish them in the other way. And, finding the right messaging, finding the right tools. How do I make this work? And then again, having all these available options, whether you're writing a letter, whether you're proposing mediation, whether you're going to have without prejudice conversation. There's just so many tools that we can.
So on that note, which is still related to what we're talking about, when you're dealing with corporate, either parties or subject matters, do you actively, either consciously or subconsciously, inject a bit of your own, not just worldviews or your opinions on morality, but what you feel is the right thing? Give an example. In the say hypothetical scenario where a company wants to go through restructuring and make a whole group of people redundant, you could, on the one hand, be well within your rights just to advise on what the law says you can or cannot do, right? And you wouldn't be out of order if you did just that. You might be, in fact, viewed as being very good and efficient. But do you, in that situation, do you find yourself either being pushed or motivated to, and do you, in fact, do a bit more and say, you know what, this is what you can do, but what you could also do without jeopardizing your corporate interests is also this, and that's the humanity coming in. Even though the subject matter in question is not one that really needs to have that.
If they're willing to listen, we're certainly willing to advise. And if we think that there is something more that should be done rather than just the bare minimum, we can tell them. As a matter of law, this is the bare minimum. But as a matter of reality,
And humanity.
and humanity. Why don't you look at this?
And do you find yourself doing that very often?
I think to anyone who would listen, yes.
Hmm.
But whether or not our sense of fair play, whether that equates someone else's, I think it's a matter of, discussion.
It's
And
true.
and we should have that
Yeah.
discussion.
Yeah.
Of course, if the corporate is going under,
Hmm.
right, and they don't have the money to pay
Hmm.
what we consider to be a better or a fair
Correct.
retrenchment, then of course it's not a conversation to be had. But where it is significant, where they can do something better.
The way that you've always practiced, it's the way that I've always observed you doing things, is also what I tried to inject into what I do too. But as we come to the conclusion for today, at least, as I said, I hope that we'll have many other conversations, whether on camera or off camera, I'm sure. Quick fire questions, okay?
Sure.
Biggest misconception people have of you as a lawyer or as a business owner or lawyers in general? Biggest misconception.
For me, probably, Tito Isaac only does litigation and nothing else.
As I said, that's because you're so good at it. That's my view. That's my answer.
Well, thank you. It's too kind. Of the fraternity, that sometimes lawyers are less approachable, far too expensive, we're very calculative. I don't think that's true at all. We've seen so many step up, right? How many answer the call for legal aid? How many give free legal clinics? So many. So that's not us. But everyone knows, even for the continuing legal training of our young lawyers, that's a significant investment the firm makes.
I'm happy that you continue to do it in the work that you do. Second one, and then there's a third. The second is this. If by choice you could do anything else, but that's not practicing law or anything to do with the legal industry, what would that be?
Diplomacy. If I've always found the work done by some of our ambassadors representing Singapore elsewhere to be very interesting, very intriguing, and I presume when you win for the country, it's very fulfilling as well. So yes, if I wasn't a lawyer, maybe I would try to do that, but I'll probably get sacked in the first week.
I think there's still a lot of mileage that you have. There's still a lot of runway that you have. So we'll come back to that. Maybe in one of the next episodes.
Sure.
Last question. Lawyer superpower. If there's one thing that you could have, what superpower would that be?
I would like to say it's about knowledge and information retention and so on, but it's really not about that. I think it's being able to see into what that particular group of people instructing us really want, really feel, and being able to address those concerns, those fears, those doubts, being able to just assure them that we are very sincere.
To see right into their hearts and into their minds.
And then address those fears.
As opposed to what they articulate.
Absolutely.
Which sometimes is not the same.
It's not the same. Many times it's not the same.
And on that note, thank you so much, Tito. I really appreciate this. I thank you in advance for the many other conversations and sessions we'll have. We'll all really enjoy talking to you and hearing from you again. So that's for today, our session, and I'm really appreciative of your time and for following us. If you like what you've heard, if you want to hear more, follow and subscribe us for more legal things.